Leader Minor-Brown.
Thank you, Madam Speaker. May I have Senate Substitute 1 for Senate Bill 2 read in for the third and final time and brought before the House for consideration.
Chief Clerk, please reading Senate Substitute 1 for Senate Bill 2.
Madam Speaker, Senate Substitute number 1 for Senate Bill number 2, sponsored by Senator Lockman and Senator Townsend and Senator Sturgeon, and Representative Minor-Brown, and Representative Bomback, and Representative Griffith, and Representative Romer, and Representative Morrison, and other senators and representatives. An act to amend Title 11, Title 24, and Title 29 of the Delaware Code relating to deadly weapons. Madam Speaker, this includes third and final reading of Senate Substitute number 1 for Senate Bill number 2.
Leader Minor-Brown, do you have a House Amendment 2 you'd like to?
Yes. Can I have House Amendment 2, please? Can I have that read in?
Chief Clerk, please read in House Amendment 2 to Senate Substitute 1 for Senate Bill 2.
Madam Speaker, House Amendment number 2 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Minor-Brown. Madam Speaker, this concludes the final reading of House Amendment number 2 to Senate Substitute number 1 for Senate Bill number 2.
Leader Minor-Brown.
Thank you, Madam Speaker. So this amendment does three things. What it does is it extends from 1 year to 2 years the length of time that a handgun qualified purchase or permit is valid from the date of issue. It also makes a technical correction to the language relating to the JP court appeal process and allows for local law enforcement agencies to ensure surrender or removal of handguns that are purchased with a revoked permit. It also removes the firearm training course voucher program and a few other corresponding technical changes. Can I have a voice vote, please?
Representative Urick.
Thank you, Madam Speaker. Just some open dialogue with the sponsor.
Mr. Brannon.
I appreciate and like some of the changes you made, for example, the 1 to the 2 years. However, I have the angst with the elimination of the voucher program. Just like to hear the rationale why we're removing that, which the fact of the matter is the training, which would have a probably sticker price, $250, $300, $400, $500, is going to be a financial challenge from individuals that are struggling already. What's the rationale for removing the voucher program?
So actually, the trainings actually are a little less than that. But we removed the voucher program because it just could not sustain in this bill at this time. But we are looking at other avenues on how we can still support the voucher program outside of this legislation.
All right, so you say I said $250, $300, $400. So what's your expected cost for the training program? What
Around $100, $130.
Maybe I'm mistaken that I was trying to benchmark it off of similar training for a concealed carry, where what we found was that it was much higher price than that to do it in person. Even if it is $150, again, for individuals that are struggling to make ends meet, that perhaps in their right to be able to defend themselves, is it so just purely on a financial matter? That's the reason you've taken it out? You just think it's going to add too much to the expense of the bill?
So I actually agree with you, and I think that I actually would love to have your assistance in trying to work towards a voucher program. This bill will not be implemented for 18 months post signage into law, so we do have time to get that done, and I fully support it.
Okay, so from the initial bill, just because the price tag, you felt it was too heavy, you just wanted to strip it all out?
I would love your assistance in working on that.
I'll take that as a yes then. So yeah, I look forward to, again, trying to provide the opportunity for individuals who are struggling the most financially. In this sense, even though I don't agree with it, to have that ability to exercise their right. Yeah, we look forward to working with you on that piece.
Thank you.
Representative Speigelman.
Thank you, Madam Speaker. Open dialogue with the bill sponsor, please. The amendment sponsor, please. Question for you, Representative Minor-Brown.
Yes.
The lines 3 and 4 of the amendment, we're talking about a local law enforcement agency being able to seize firearms, in particular handguns, that were purchased under a permit that is then revoked. Is that the case? I mean, walk me through this. There's kind of two thoughts here. There's somebody who purchased who has the permit, who in the course of the 2 years that will be valid, purchases handguns legally under the permit system. The permit is revoked. And then there's the other thought of a person who has a revoked permit who then attempts to purchase a handgun. So in particular, which of these two scenarios is this referring to?
I'm really not understanding your question. Can you repeat it?
Sure. So we've got two scenarios under which that I'm struggling to understand here. So on the one hand, we have a situation in which a person has the permit, uses it to purchase a handgun, perfectly legal. The permit is then revoked for a reason. Lethal violence protection order, for example. The permit is then revoked. Is this giving the local law enforcement agency, and I realize that we're moving state police, now we're adding local law enforcement agency. This gives them the ability to not only physically revoke the permit, but also go to the person's house and revoke the firearms that were purchased under the permit.
It allows them to ensure that surrender or removal of that handgun is completed.
Okay. How do they know they have the handgun?
Why don't I call someone up to help answer that question?
Appreciate it.
Does
Thank
that
you.
help?
Yeah.
All right. Let me just see, is Secretary McQueen here?
Secretary McQueen, please come forward. Just state your name for the record.
It is. It is. We'll see. Yeah.
Nathaniel McQueen, Secretary for Safety and Homeland Security.
Thank you. You want to ask your question again?
Thank you, Mr. Secretary. Appreciate you being here.
Yes, sir.
Did you hear the question, or you would like me to go through it again?
Yes, sir. I heard your question.
Okay.
The way you present the question, will it give local law enforcement the authority to go and remove, one, take the permit back and remove weapons? Yes.
Okay. So local law enforcement agencies, some of Delaware's finest, go into person's home. They physically remove the permit, of course, and then they physically remove the handgun itself, or any of the firearms that are housed there, or is it just the ones that are housed that are the handguns that were purchased under the permit system?
All the ones that are purchased, all the weapons in the home.
All the weapons in the home. Okay. So under the permit system, are we creating any sort of registry in which Delaware's, the local law enforcement agency, state police, is there a registry of the firearms that were purchased under the permit program that then the state police, local law enforcement agency would then go and retrieve under the situations I'm describing?
The purpose of the program is not to create a registry, but you would have documentation of any weapons purchased under the permit, yes. We would have records of any firearms that were purchased with the permit to purchase card, yes.
So there is a record of the firearms purchased, the handguns purchased under the firearm card.
According to the legislation, yes, sir.
Okay.
Representative Speigelman, may I just add, you're kind of on the bill, so it's hard for the secretary to answer that with not having the bill already been passed. So,
Mr. Secretary, I'll be back with you in a minute.
there you go.
Thank you, sir.
Yes, sir.
Any other questions for the secretary? Representative Ramon.
Thank you, Madam Chair. I just am curious, do we, I know we have something out there waiting to start being implemented that personnel issues, I believe, is preventing it from getting done right away, but do we actually have any kind of quantitative people that are going to be able to do that? I mean, who's going to perform these jobs?
Representative Ramon, again, could we get through this amendment specifically, and then that will be answered in the actual bill?
No, I understand, but I mean, in the amendment, it says the way that it's been rewritten, a filing fee is not registered to be to obtain a hearing, right? And then it says the justice of the peace court shall designate a simple form for initiating. I'm assuming that's to reduce staff and redundancy and extra effort with you guys. Does that help or not? Do you have enough people to be able to perform this? And does this amendment help you in that particular
Madam
aspect?
Speaker, this is actually
No?
related to the actual bill. This isn't related to the amendment.
Okay.
That's
But it
that's
is on the amendment. Okay. Well, okay. We'll talk about it later. Can I have a roll call then?
I have a question.
Well,
ma'am.
we're not done yet.
Sorry.
Representative Urick.
Thank you, Madam Speaker. This is on the amendment. When you say revoke,
Representative Urick, can you turn on your mic? And
There we go.
anybody that has their mic on at this point, please turn it off after you're done speaking, because that's what you're hearing, that buzz. Thank you.
thank you. Could you just clarify, when it's literally revoking the permit, what does that mean?
It would be taken back to permit that they were received from SBI.
So that physical piece of paper, that is the only form of verification whenever they go to execute to use it. It's a piece of paper. So you're going to literally be revoking that piece of paper in that current form.
According to the legislation, yes, sir.
All right, thank you.
Anybody else? Leader Minor Brown?
We'd like to have a
Voice
roll call
vote,
on that.
please.
Okay. Chief Clerk, please read the roll call on House Amendment 2 to Senate Substitute 1 to Senate Bill 2. What's that? Oh, Secretary, you're excused for now. I'd stay closer.
Mr. Bomback?
Yes.
Mr. Bomback, yes. Ms. Bolden?
Yes.
Ms. Bolden, yes. Mr. Bush?
Yes.
Mr. Bush, yes. Mr. Carson? Yes. Mr. Carson, yes. Mr. Chikwocha?
Yes.
Mr. Chikwocha, yes. Mr. Collins? Mr. Collins not voting. Mr. Cook?
Yes.
Mr. Cook, yes. Mrs. Dorsey Walker?
Yes.
Mrs. Dorsey Walker, yes. Ms. Dukes? Mr. Dukes? Mr. Dukes not voting. Mr. Gray? Mr. Gray not voting. Mrs. Griffith? Mrs. Griffith, yes. Ms. Harris?
Yes.
Ms. Harris, yes. Mrs. Heffernan? Mrs. Heffernan, yes. Mr. Hensley? Mr. Hensley, yes. Mr. Holofsky? Mr. Holofsky not voting. Mrs. Johnson?
Yes.
Mrs. Johnson, yes. Mrs. Jones-Giltner?
Not voting.
Mrs. Jones-Giltner not voting. Mr. Lambert? Mr. Lambert, yes. Mr. Lynn? Mr. Lynn, yes. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor Brown? Mrs. Minor Brown, yes. Ms. Moore? Ms. Moore, yes. Mr. Morris? Mr. Morris, no. Mr. Morrison? Mr. Morrison, yes. McSneil? McSneil, yes. Mr. Osinski?
Yes.
Mr. Osinski, yes. Ms. Parker Selby? Ms. Parker Selby, yes. Ms. Phillips? Ms. Phillips, yes. Mr. Postles? Mr. Postles, no. Mr. Ramon? Mr. Ramon not voting. Ms. Romer? Ms. Romer, yes. Mr. Schwarzkopf? Mr. Schwarzkopf, yes. Mr. Short? Mr. Short, yes. Mr. Shoup? Mr. Shoup not voting. Mr. Smith? Mr. Smith not voting. Mr. Spiegelman? Mr. Spiegelman, yes. Mr. Vanderwyn? Mr. Vanderwyn, no. Mrs. Williams? Mrs. Williams, yes. Mrs. Wilson-Anton? Mrs. Wilson-Anton, yes. Mr. Yerrick? Mr. Yerrick, no. Madam Speaker?
Yes.
Madam Speaker, yes. Madam Speaker, the roll call reveals 29 yes, 4 no, 8 not voting.
Having received a constitutional majority, House Amendment 2 to Senate Substitute 1 for Senate Bill number 2 is declared passed the House. Representative Yerrick.
Thank you, Madam Speaker. I have an amendment I'd like to introduce.
Chief Clerk, can you read House Amendment 3 to Senate Substitute 1 for Senate Bill 2?
Madam Speaker, House Amendment number 3 to Senate Substitute number 1 to Senate Bill number 2, sponsored by Representative Yerrick. Madam Speaker, this is the final reading of House Amendment number 3 to Senate Substitute number 1 to Senate Bill number 2.
Representative Yerrick. House Amendment 3 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. The intent of the amendment is, and we have two major parts. One is the completion of the training and getting access to someone to complete the training, which could take months. But that's not what the intent of the amendment is. We're looking at trying to enhance efficiency, speed, accuracy when we get to the actual completion of the permit. Be able and willing to answer any questions on the amendment?
Leader Minor Brown.
Thank you, Madam Speaker. This is an unfriendly amendment because it removes important safeguards that are built into the handgun qualified purchaser permit for that exact purpose of making certain that permits are issued only after appropriate investigation has been undertaken and a fingerprint background check is conducted.
I can appreciate that. However, I would disagree, and I'd like to have a roll call on it.
Chief Clerk, please read the roll on House Amendment 3 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback?
No.
Mr. Bomback, no. Ms. Bolden? Ms. Bolden, no. Mr. Bush?
No.
Mr. Bush, no. Mr. Carson? Mr. Carson, no. Mr. Chikwocha?
No.
Mr. Chikwocha, no. Mr. Collins? Mr. Collins, yes. Mr. Cook?
No.
Mr. Cook, no. Mrs. Dorsey Walker?
No.
Mrs. Dorsey Walker, no. Mr. Dukes? Mr. Dukes, yes. Mr. Gray? Mr. Gray, yes. Mrs. Griffith?
No.
Mrs. Griffith, no. Ms. Harris? Ms. Harris, no. Mrs. Heffernan? Mrs. Heffernan, no. Mr. Hensley? Mr. Hensley, yes. Mr. Holofsky? Mr. Holofsky, yes. Mrs. Johnson?
No.
Mrs. Johnson, no. Mrs. Jones-Giltner?
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert? Mr. Lambert, no. Mr. Lynn? Mr. Lynn, no. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor Brown?
No.
Mrs. Minor Brown, no. Ms. Moore? Ms. Moore, no. Mr. Morris? Mr. Morris, yes. Mr. Morrison? Mr. Morrison, no. Mix Neal? Mix Neal, no. Mr. Osinski?
No.
Mr. Osinski, no. Ms. Parker Selby? Ms. Parker Selby, no. Ms. Phillips? No. Ms. Phillips, no. Mr. Postles? Mr. Postles, yes. Mr. Ramon? Mr. Ramon, yes. Ms. Romer? Ms. Romer, absent. Mr. Schwarzkopf? Mr. Schwarzkopf, no. Mr. Short? Mr. Short, yes. Mr. Shoup? Mr. Shoup, yes. Mr. Smith? Mr. Smith, yes. Mr. Spiegelman? Mr. Spiegelman, yes. Mr. Vanderwyn? Mr. Vanderwyn, yes. Mrs. Williams? Mrs. Williams, no. Mrs. Wilson-Anton? Mrs. Wilson-Anton, no. Mr. Yerrick? Mr. Yerrick, yes. Madam Speaker?
No.
Madam Speaker, no. Madam Speaker, the roll call reveals 16 yes, 24 no, 1 absent.
Having failed to receive a constitutional majority, House Amendment 3 to Senate Substitute 1 for Senate Bill 2 has failed to pass. Leader, who's next? Representative Spiegelman.
Thank you, Madam Speaker. May I please have House Amendment 4 read in?
Chief Clerk, please read in House Amendment 1 to House Amendment 4 to Senate Substitute 1 for Senate Bill 2.
Madam Speaker, House Amendment number 4 to Senate Substitute number 1 to Senate Bill number 2, sponsored by Representative Spiegelman. Madam Speaker, this includes final reading of House Amendment number 4 to Senate Substitute number 1 to Senate Bill number 2.
Representative Spiegelman, do you have another amendment?
Yes, Madam Speaker, I'd like to apologize to my colleagues. In reviewing this amendment, I did find something that really did need to be changed. I apologize for the lateness of the amendment. I do have House Amendment 1 to House Amendment 4 to Senate Substitute 1 for Senate Bill 2. Good luck to us all.
Please pass it out.
No. I appreciate that. Thank you. Oh.
Chief Clerk. Read in House Amendment 1 to House Amendment 4.
Madam Speaker, House Amendment number 1 to House Amendment number 4 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Spiegelman. Madam Speaker, this includes final reading of House Amendment number 1 to House Amendment number 4 to Senate Substitute number 1 to Senate Bill number 2.
Thank you. Representative Spiegelman, House Amendment 1 to House Amendment 4 is before us.
Thank you, Madam Speaker. Again, I beg the indulgence of my colleagues. I thought that this amendment was more within the spirit of what we were trying to accomplish with House Amendment 4. Can I please have a voice vote?
All those in favor to House Amendment 1 to House Amendment 4 signify by saying aye.
Aye.
Nays? No. Nays have it. The House Amendment 1 to House Amendment 4 is defeated. Representative Spiegelman, House Amendment 4 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. What House Amendment 4 does, within the bill itself, there are 3 exceptions to the bill: qualified law enforcement officers, qualified retired law enforcement officers, and concealed carry permit holders. What House Amendment 4 does is it adds people who either already have training or that we trust to protect our children, trust to protect our correctional facilities, and trust to protect our state and nation from having to require a permit, especially when a lot of these people already are required to get training. In particular, members of our military are already required to qualify on a pistol once a year anyway. To have them qualify on a pistol in part of their normal duties as a member of the armed services, to then turn around and say, oh, well, you have to then get a handgun permit, which requires fingerprinting and qualification on that same firearm, is a little strange and, frankly, a little insulting to members of our armed services. We have constables. We just, Representative Schwarzkopf just did a bill not too long ago that added constables to those who are allowed to carry firearms in schools. So we trust them protect our children with a firearm, but then we require them in their personal lives to go out and get a permit and qualify in order to have a gun in their personal lives. It's a little strange to me that that would be the case. Delaware correctional officers are in the same boat. These are people who carry a firearm as part of their normal job that we ask them to do. We then turn around and say, oh, but in order to have a firearm in your personal life, we require you to go get a permit, to go get fingerprinted, to do all of these things that are required of them, even though they strap a firearm to their hip every day going and doing the job that we require them to do. So in that spirit, I'm asking for my colleagues' support on House Amendment 4 to, well, you know the rest.
Leader Minor Brown.
Thank you, Madam Speaker. I see this as an unfriendly amendment. Anyone who's required to undergo firearm training as part of their job will already have proof of training to submit for their permit. They don't have to undergo additional training. So adding categorical exemptions, this makes the process more difficult for SBI to administer. So I see it as unfriendly.
Representative Ramon.
Madam Speaker, can we have the Attorney General's office come in and say if that's actually true or not, that the way this bill's written, that they would not have to go through this?
Attorney General Kathy Jennings, come forward and just say your name. Or you good? Just state your name for the record.
Attorney General Jennings, you understand what I'm asking. We're just trying
I
to put...
do not. So
Oh, okay. We are trying to have an initiative of putting together some amendments that would have a higher level of efficiency, reduced redundancy of trying to get people from having to go through classes when they've already clearly qualified, clearly trusted, and it appears that the sponsor of the bill believes that they do not have to go through the class. I am asking you if that's accurate or not. No? Or
So-
go ahead.
here's what I would say to that. It's pretty clear in the bill that any qualified law enforcement officer can avoid having to go through the permit process. And it is true that a person applying for a handgun purchase or permit as a qualified officer or a qualified retired law enforcement officer is not subject to the requirement. And a person who has a valid carry conceal permit is not subject to the requirement.
So, yeah, thank you. So, but the others that are listed in the amendment, I don't know if you were looking.
I haven't seen the amendment. I'm looking at it for the first time.
Yes,
Thank you.
I understand. I'm just asking because you're going to be the one who's going to have to either, somebody violates, they violate. And I would like to know if somebody's confused, they think they have this and they don't have to do the test, and then they do, and you have some that don't and some that do. This is just a nice, clean list of who would be able to just, because of the trust in the community, I'm just questioning the fact that it was unfriendly. I thought it would be a good one to help your office not have to go through clarity, and also help the colonel without having to have as many people have to go through the class.
Thank you, and I appreciate the motivation and the efforts. I will tell you that Attorney General and Deputy Attorneys General are not otherwise trained or qualified right now. That's not a requirement of holding the office or holding the job as a Deputy Attorney General. So in my personal opinion, it'd be pretty gosh darn important for them to get training before they got a permit to purchase.
Yeah, if you don't mind, can I just defer to the sponsor of the amendment, and you keep that, give it back to me when he's done. Okay.
Spiegelman, do you have a question for Attorney General?
I do. Thank you, Madam Attorney General. I would also like to point out that I happen to agree with you, which was the point of the amendment that was just struck down, that the Attorney General and Deputy Attorney Generals would have to be otherwise qualified. That was the amendment that was just struck down by my friends on the other side. But I'd like to ask this question. Is these people on this list, are they able to present some sort of documentation that says we've already gone through training So we are exempt from the training side of the permit to purchase language in Senate Substitute 2.
So, can I
That-
go back that
it's-
you're going to the bill? We haven't.
With respect, Madam Speaker, I'm not. I'm asking about the people on this
Okay.
list
Okay.
in House Amendment 4.
Okay.
If they can present, in other words, if a member of our armed services can present that they do pistol training once a year, they have to. They can present some sort of, and I hate to use the word voucher because it means something else in this bill, but they can present some sort of certificate, I guess. It says, hi, I'm in the Army National Guard, and thank you for being in the Army National Guard. Here is my training certificate for my pistol qualification. That exempts me from having to do any sort of training as part of permit to purchase. Is that correct?
If the training comports with the requirements in the bill, that it include knowledge of the law, that it include safe storage, that it include other aspects that are required within the bill itself, yes.
So in other words, the training that a correctional officer goes through may not have that training included because they're getting trained on a pistol for a part of their job. So in theory then, they could still have to go through the very specific training for this bill, even though they are trained for a pistol as part of their job as a correctional officer, constable, armored car guard, member of the armed services.
So, Representative, I think it's important that we look at the section of the bill that instructs us as to what the training required is. And let's start with line 49, instruction regarding knowledge and safe handling of firearms. Line 50, instruction regarding safe storage of firearms and child safety. Line 51, instruction regarding knowledge and safe handling of ammunition. Instruction regarding safe storage of ammunition and child safety. Instruction regarding safe firearms shooting fundamentals. Live fire shooting exercises conducted on a range. And so I do not know what all of the individuals listed in your proposed amendment have received training on, but the training that is required by this bill is broader than proficiency training.
And I appreciate that. So that would have me believe that statement that you just made, and thank you for that, would actually be in opposition to the statement that the majority leader made, that these people already qualify under their training that they get to avoid the training in the permit to purchase side of things.
Okay, that was a very long question, but I think I got it.
I do that. Yeah, I do that. And I apologize for that.
I believe that the majority leader was indicating that people who are trained in how to use firearms absolutely have completed one of the many requirements in the bill, but not perhaps all of those requirements in the bill, because we're looking not just at proficiency to shoot, we are looking at all the other aspects. How do you safely store a firearm? How do you make sure that you know the laws? How are you making sure that you know child safety, storage, and protection of children when you have a firearm? How do you know that you have instruction regarding federal and state laws pertaining to the lawful purchase, ownership, etc., and possession of firearms? I don't know that all of the people on this list, which I'm seeing for the first time, would qualify under this bill.
I appreciate that. It sounds to me that, and with respect to both of you, it sounds to me that your objections to this amendment are perhaps different than the majority leader's objections to this amendment. I do find that interesting. And I would also make one more point to what you're saying, is that even if Representative Minor-Brown is right and that you are incorrect, with respect, that these people would still need to go through the permitting process. So we're still asking members of our armed services, correctional officers, constables, armored car guards to get fingerprinted and have to go through the permitting process side of things as well, never mind the training side of this. So even if Representative Minor-Brown is right and you're wrong, and I'm not going to make that judgment, I just find it interesting we got two different objections here, these people, we're still forcing them to go get fingerprinted.
It says under this bill that the SBI, the State Bureau of Identification, shall on application issue a handgun qualified purchaser permit to all of the following: a qualified law enforcement officer, a qualified retired law enforcement officer. You have these individuals, it looks like, on this amended
I'm sorry.
list.
I'm sorry. Are constables law enforcement officers?
No, it says I did not say that. I
Okay.
said a qualified law enforcement officer or a retired law enforcement officer who's qualified. And I believe that's what the House Majority Leader was speaking to.
Okay.
So they shall get issued a permit.
So in other words, a member of the armed service would still have to get fingerprinted. A constable would still need to be fingerprinted. A corrections officer still need to be fingerprinted. Armored car guard still need to be fingerprinted. Still need to go through the training process. All of those things.
The training would not apply if a person is a law enforcement officer or a retired law enforcement officer.
Okay, thank you.
Thank you.
Roll call, please.
May I be excused? Yes, you may. Thank you. For now.
Please read the roll on. Sorry. Please read the roll on House Amendment 4 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback.
No.
Mr. Bomback, no. Ms. Bolden.
No.
Ms. Bolden, no. Mr. Bush.
No.
Mr. Bush, no. Mr. Carson. Mr. Carson, yes. Mr. Chikwocha.
No.
Mr. Chikwocha, no. Mr. Collins. Mr. Collins, yes. Mr. Cook.
Yes.
Mr. Cook, yes. Mrs. Dorsey Walker.
No.
Mrs. Dorsey Walker, no. Mr. Dukes. Mr. Dukes, yes. Mr. Gray. Mr. Gray, yes. Mrs. Griffith. Mrs. Griffith, no. Ms. Harris.
No, because as written, it would be more restrictive than that's currently
Ms.
written.
Harris, no. Mrs. Heffernan. Mrs. Heffernan, no. Mr. Hensley. Mr. Hensley, yes. Mr. Hilofsky. Mr. Hilofsky, yes. Mrs. Johnson. Mrs. Johnson, no. Mrs. Jones-Giltner.
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert. Mr. Lambert, no. Mr. Lynn. Mr. Lynn, no. Mr. Matthews. Mr. Matthews, yes. Mrs. Minor-Brown.
No.
Mrs. Minor-Brown, no. Ms. Moore. Ms. Moore, no. Mr. Morris. Mr. Morris, yes. Mr. Morrison. Mr. Morrison, no. Mixed Neal. Mixed Neal, no. Mr. Osinski.
No.
Mr. Osinski, no. Ms. Parker-Selby. Ms. Parker-Selby, yes. Ms. Phillips. Ms. Phillips, no. Mr. Postles. Mr. Postles, yes. Mr. Ramon. Mr. Ramon, yes. Ms. Romer. Ms. Romer, no. Mr. Schwarzkopf. Mr. Schwarzkopf, no. Mr. Short. Mr. Short, yes. Mr. Shoup. Mr. Shoup, yes. Mr. Smith. Mr. Smith, yes. Mr. Spiegelman. Yes. Mr. Spiegelman, yes. Mr. Vanderwyn. Mr. Vanderwyn, yes. Mrs. Williams. Mrs. Williams, no. Mrs. Wilson-Anton. Mrs. Wilson-Anton, no. Mr. Yerrick. Mr. Yerrick, yes. Madam Speaker.
No.
Madam Speaker, no. Madam Speaker, the roll call reveals 19 yes, 22 no.
Having failed to receive the constitutional amendment, House Amendment 4 to Senate Substitute 1 for Senate Bill 2 has been defeated from the House. Representative Spiegelman, you have an House Amendment 5.
Madam Speaker, if I have intention of striking House Amendment 5, do I have to strike House Amendment 1 first?
No, because it hasn't been introduced yet, so.
I'd like to strike House Amendment 5.
House Amendment 5 to Senate Substitute 1 for Senate Bill 2 has been struck. So now we have House Amendment 1 to House Amendment 5 before, no? Oh, we're done? Oh,
I think we're on House Amendment 6.
okay, got it. Okay. Representative Spiegelman, House Amendment 6 to Senate Substitute 1 for Senate Bill 2 is, what would you like to have it read in?
Please. No, you're good. You can sit. Yeah, you're good. I'm not going to make you walk anymore.
By title only.
Madam Speaker, House Amendment number 6 to Senate Substitute number 1 to Senate Bill number 2, sponsored by Representative Spiegelman. Madam Speaker, this concludes the final reading of House Amendment 6 to Senate Substitute number 1 to Senate Bill number 2.
Representative Spiegelman, House Amendment 6 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. House Amendment 6 exempts certain groups from just the training part of the permit. In other words, these people still have to get fingerprinted, they'll still have to get a permit, but it exempts them from the training. Groups include the instructors that we're saying are qualified to teach the class, would then be exempted from having to take the class themselves, which I think is a little ridiculous. It includes competitive shooters. It includes, again, members of our armed service, correctional officers, constables, armored car guards, FFLs, and others.
Leader Minor Brown.
Thank you, Madam Speaker. I see this amendment, House Amendment 6, as unfriendly. Part of it is redundant, and part of it makes the statute more difficult for SBI to administer and for licensed dealers to understand. And I believe it's more restrictive than the original bill.
Representative Spiegelman.
I just want to point out again that we are requiring the instructors that we're teaching the class, we're requiring constables that we trust to carry a gun in a school to protect our children. We're requiring them have to get extra training to buy a gun for themselves and get permitted and fingerprinted, which they already have to do as part of their jobs. And no, they are not law enforcement officers. I'll have a roll call.
Chief Clerk, please read the roll on House Amendment 6 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback?
No.
Mr. Bomback, no. Ms. Bolden?
No.
Ms. Bolden, no. Mr. Bush? Mr. Bush, no. Mr. Carson? Mr. Carson, yes. Mr. Chikwocha? Mr. Chikwocha, absent. Mr. Collins? Mr. Collins, yes. Mr. Cook? Mr. Cook, yes. Mrs. Dorsey Walker?
Yes.
Mrs. Dorsey Walker, yes. Mr. Dukes? Mr. Dukes, yes. Mr. Gray? Mr. Gray, yes. Mrs. Griffith? Mrs. Griffith, no. Ms. Harris?
No.
Ms. Harris, no. Mrs. Heffernan? Mrs. Heffernan, no. Mr. Hensley? Mr. Hensley, yes. Mr. Hlowski? Mr. Hlowski, yes. Mrs. Johnson? Mrs. Johnson, no. Mrs. Jones-Giltner?
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert? Mr. Lambert, no. Mr. Lynn? Mr. Lynn, no. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor Brown? Mrs. Minor Brown, no. Ms. Moore?
Yes.
Ms. Moore, yes. Mr. Morris? Mr. Morris, yes. Mr. Morrison?
Sorry, no.
Mr. Morrison voting no. McSneil?
No.
McSneil, no. Mr. Osinski?
No.
Mr. Osinski, no. Ms. Parker-Selby?
Yes.
Ms. Parker-Selby, yes. Ms. Phillips? Ms. Phillips, no. Mr. Postles? Yes. Mr. Postles, yes. Mr. Ramon? Yes. Mr. Ramon, yes. Ms. Romer? Ms. Romer, no. Mr. Schwarzkopf? Mr. Schwarzkopf, no. Mr. Short? Mr. Short, yes. Mr. Shoup? Mr. Shoup, yes. Mr. Smith? Mr. Smith, yes. Mr. Spiegelman?
Yes.
Mr. Spiegelman, yes. Mr. Vanderwin?
Yes.
Mr. Vanderwin, yes. Mrs. Williams? Mrs. Williams? Mrs. Williams? No. Mrs. Williams voting no. Mrs. Wilson-Anton?
Yes.
Yes. Mrs. Wilson-Anton voting yes. Mr. Yerrick? Mr. Yerrick, yes. Madam Speaker?
No.
Madam Speaker, no. Mr. Chikwocha?
Representative Chikwocha.
From absent to no.
Mr. Chikwocha from absent to voting no.
Madam Speaker, what's the current roll call, please?
The roll call is 22 yes, 19 no.
Thank you.
Madam Speaker, the roll call reveals 22 yes, 19 no.
Having received a constitutional majority, House Amendment 6 to Senate Substitute 1 for Senate Bill 2 has been declared passed the House. Representative Giltner, do you have an amendment you'd like to have read in?
Yes, please, Madam Speaker. I'd like to have House Amendment number 7 to Senate Substitute number 1 for Senate Bill number 2 read in, please.
Chief Clerk, please read in House Amendment 7 to Senate Substitute 1 for Senate Bill 2.
Madam Speaker, House Amendment number 7 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Smith and Representative Jones-Giltner. Madam Speaker, this concludes the final reading of House Amendment number 7 to Senate Substitute number 1 to Senate Bill number 2.
Representative Giltner, House Amendment 7 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. This amendment recognizes that there are persons whom the court also recognizes that are vulnerable or at risk of physical abuse or attack, and offers an expedited manner for them to get a permit to purchase. The moment that you realize that you need to file for a protection from abuse order is a life-changing moment, and I pray that no one has to experience it. And for those that have, I pray for you to recover from that traumatic experience. But in that moment, when you gather the courage to file for a PFA and you start to lay out your plan for how you're going to protect yourself, there also comes the realization that the PFA may enrage your partner to the point that their abuse will increase. Because domestic violence actually sees more women experiencing it frequently, I speak for the women of my district and others in the state. Because during that courageous state of planning for your survival, we, as a legislation, cannot block or delay the person's right to equip themselves with a gun for protection. If there are no questions, I'd like to ask for a roll call.
Dialogue with
Yes,
the
you
amendments. Thank you. Representative Jones-Giltner, what did the Coalition Against Domestic Violence tell you about your proposed amendment when you consulted with them?
I actually sought input from the Women's Defense.
Yeah, and if you can just answer my question, which is, what answer did the Delaware Coalition Against Domestic Violence give you when you asked their opinion of this amendment?
No answer.
You didn't speak to them?
No, I spoke to others.
Okay. What did People's Place say to you about this amendment?
I didn't talk to People's Place.
What did Child Inc. say to you about this amendment?
You know, I could stand here and answer individual
please, if you
ones,
could.
but I sought input from others.
Okay,
It
I'm
might not
asking
be
you
the
about-
same as what you're asking.
If you can
Representative
answer
Giltner,
my
Representative
question.
Griffith, let one of them finish and then the other one can make a statement, please. Go ahead, Representative Griffith.
Thank you. My question to you, ma'am, is what did Child Inc. say to you about this amendment?
Madam Speaker, I would say this is out of order simply because it doesn't matter what the guy on the side of the street or what other groups that this particular representative thinks is relevant. If she has a question, let the person answer the question or give the list of people and say, I've spoke to this one or that one. I think otherwise we're kind of out of order and it's being a little belligerent.
To me, it's important.
Representative Griffith, I appreciate that, Representative Ramon, but Representative Griffith, can you lump all the people that you were
Yes.
asking if she got a hold of the stakeholders
Sure.
in one?
Thank you. Representative Smith, who is on the Domestic Violence Coordinating Council, is a member of is one of the sponsors on this. It actually looks like the prime sponsor of the amendment. I serve on the Domestic Violence Coordinating Council with him, and I don't recall this topic ever being raised at any commission hearing. So I'm concerned that the leading stakeholders in this state that deal with domestic violence issues and specifically how to reduce incidents of domestic violence have not been consulted on this amendment. I'm also concerned that other of those system and non-system based advocates for victims of domestic violence were not consulted on this amendment. And those include the Delaware Coalition Against Domestic Violence, per the amendment sponsor speaking today, Child Inc. and People's Place were not consulted. It also seems to me that she did not consult with the domestic violence unit of the Delaware Department of Justice or others. So to propose an amendment which tends to say would reduce or help vulnerable individuals concerns me when those leading organizations, which are part of the state commission, of which Representative Smith serves on, haven't been consulted, is deeply concerning to me. Further, this amendment also includes anybody who has received a no contact order or someone who's gotten a no contact order. Those individuals include way more folks than those that are just victims of domestic violence. It could be neighbors in a neighbor dispute, or anyone really who is a victim of a crime who gets a no contact order in a JP court or other jurisdiction. So it just concerns me that the amendment sponsor is purporting to state that this would help vulnerable individuals when she hasn't gone to those individuals who are the leaders in this state on this very issue. And that's all I have to say. Thank you.
I have Representative Smith, and then I have Representative Spiegelman, Representative Minor Brown, and Representative Lynn.
Thank you, Madam Speaker. I realized I was called out because she wanted me to run the amendment so that she could do that. So I'll respond. One, you can't really get their input included when you didn't know the bill was going to be running today until last night. So I'll first say that. To say that we didn't get voices heard despite not talking to organizations would be a false claim. We've talked to people that have had domestic violence committed against them. Heck, I've stopped someone who was committing domestic violence in my mom's ex-husband. So I'm certainly not going to have you come here and try to chastise us. Because I'd like to ask you, did you actually get law enforcement's input on the bill itself? Thank you.
You don't need to answer that. Representative Spiegelman.
Thank you, Madam Speaker. Question for the amendment sponsor, please. Representative Jones-Giltner, you mentioned that you did speak to an organization. Can you please tell us what organization that was and what they had to say about the amendment, please?
Representative Giltner.
The Women's Defense Coalition supports it. They don't support SB 1 for SB 2, but this amendment would allow the expedition of a permit to purchase.
Thank you. So you did speak to a group that does have a vested interest in their well-being in this field. I appreciate that. Thank you.
Yep.
Representative Lynn.
Thank you, Madam Speaker. Representative Jones-Giltner, I want to say thank you for introducing this amendment. Like many of the amendments that your colleagues have introduced, there's a lot of excellent ideas contained in many of the amendments. Many of the amendments are amendments that I would like to support where there are a bit more refinement to some of the fledgling ideas that I see in them. However, just simply by virtue of the logistics and mechanics of their late introduction, some of the fledgling ideas that are contained in many of these amendments, we haven't had the time to work through to finesse them and get them into a place where I would feel comfortable voting on them. Yours in particular was one that I think we all discussed this afternoon as one of the ones that has significant merit. However, I don't believe that it's quite ready yet. And some of the reasons why are no fault of yours. So, for example, while the no contact orders may be issued by the Justice of the Peace Court, you list the other courts which may do bond modification hearings and modify some of those bonds. But one important court that was missed in the drafting by your drafting attorney is family court. So family court isn't contained in the enumerated list, and they handle a significant amount of DV cases. So it's one of those little refinements that had we had an opportunity to discuss, I would work with you on this bill. Similarly, the usage of protection from abuse orders as a barometer for the issuance of kind of an exception to the permit to purchase. Again, fantastic idea, but it just needs a bit more refinement. Does it apply to ex parte PFA orders in general? Just little nuanced questions that I think had this come out just a little bit before, I would like to vote for this and pass it. And I think that goes with many of my colleagues on the other side who have fledgling great ideas in some of these amendments that just need a bit more time. So what I would ask is that once we conclude today's proceedings, however they go, that we meet and discuss this and perhaps introduce another bill that perhaps modifies it later. But I did want to say thank you for your efforts, because I think it's an excellent idea, and I think that your heart is absolutely in the right place. So thank you, Representative.
And thank you, and I'm new to this, but it sounds like you may be asking to table SB 2.
So I think it's a great idea, but I'm not quite prepared to go that far. Thank you.
Representative Ramon, would you like to add?
Thank you, Madam Speaker. I would just wanted to say, and Representative Lynn, I absolutely respect everything you just said. And unfortunately, the way politics works, when you're 15 or 41, you're rendered to an obligation of basically trying to curtail unintended consequences. This bill is trying to do that. Maybe not worded correctly. I don't know that it's totally fair to say, that we didn't have time because it was a while ago. But Madam Chair, Madam Speaker and Leader, as I think you both know, when we get a bill to the point where we're trying to, it's going to go on the agenda, we didn't have much notice. And I'm not going to get too deep into the weeds with this, but even some of our colleagues who would have gotten information in some sort of a discussion at appropriations to get some clarity, how that went. So there's been, the way this thing's gotten here has been a little unique. Having said that, I think the problem that I'm facing is voting on a bill that could end up having an environment where a woman, is forced to either break the law to keep her family or her children safe, or go through a period of time in hiding and hoping this doesn't happen. My Leader Brown, I was on the Family Law Commission for 10 years. I did sit with the judges. I sat with the every single segment of every group. I was here every single year for hours listening to people who were so scared to death for their lives and their children's lives. And I'm going to say they weren't even always women. It was just someone who felt someone else was maybe unhinged for whatever reasons. And I always felt my number one obligation for the 10 years I was on that is to err in the environment of keeping people safe. And I do believe we're trying to do that by actually having more gun safety education and also trying to protect those who are most vulnerable and trying to do it in a way that's digestible and affordable and efficient, not overloaded and delayed and not effective. So from that standpoint, Representative Lim, you're right. It would have been nice if we could have all talked together and do it maybe for many bills, but we don't always get afforded that opportunity. And often I think my new colleague over here jumped the gun on me. Kind of was a step ahead of me. Often when we have those environments, Representative Bomback, many of the people on your side and ours have tabled bills for us to readjust, reconfigure, make a couple modifications, and bring it back. With that light, I will ask for the bill to be tabled, and I would ask for a roll call.
Second. To have it tabled.
Yes, ma'am.
Okay, and thank you. What I want to add is that I want to thank Representative Lim because he did agree to work with you, and it is something that I think everybody in this room is passionate about. So thank you, Representative Lim. It's been asked to be tabled, second to be tabled. So
point of order: the bill is not up. The amendment is up. Is that correct?
Anytime during discussion.
Actually, she should strike the amendment.
A bill can be tabled anytime during discussion. You have a House attorney, let him come up and answer.
All right, the House Amendment 7 to Senate Substitute 1 to Senate Bill 2 has been tabled. Thank you.
That's not the intent.
I'm sorry?
It's been tabled.
No, I'm asking for the bill to be tabled during
you're asking
discussion.
the bill to be tabled?
Yes, ma'am. Yes, Ms. Speaker.
Okay, we have a roll call, or we have a motion and a second to table the bill.
Mm-hmm.
So I will go to a roll call on Senate Substitute 1 for Senate Bill 2 to table it. Mr. Chief Clerk, please read the roll.
Mr. Bomback. No. Mr. Bomback, no. Ms. Bolden.
No.
Ms. Bolden, no. Mr. Bush.
No.
Mr. Bush, no. Mr. Carson. Mr. Carson, no. Mr. Chikwocha.
No.
Mr. Chikwocha, no. Mr. Collins. Mr. Collins, yes. Mr. Cook.
No.
Mr. Cook, no. Mrs. Dorsey Walker.
No.
Mrs. Dorsey Walker, no. Mr. Dukes. Mr. Dukes, yes. Mr. Gray. Mr. Gray, yes. Mrs. Griffith. Mrs. Griffith, no. Mrs. Harris. No. Ms. Harris, no. Mrs. Heffernan. Mrs. Heffernan, no. Mr. Hensley. Mr. Hensley, yes. Mr. Holofsky. Mr. Holofsky, yes. Mrs. Johnson.
No.
Mrs. Johnson, no. Mrs. Jones-Giltner.
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert.
No.
Mr. Lambert, no. Mr. Lynn. Mr. Lynn, no. Mr. Matthews. Mr. Matthews, no. Mrs. Minor Brown. Mrs. Minor Brown, no. Ms. Moore. Ms. Moore, no. Mr. Morris. Mr. Morris, yes. Mr. Morrison. Mr. Morrison, no. McSneil. McSneil, no. Mr. Osinski.
No.
Mr. Osinski, no. Ms. Parker Selby. No. Mrs. Parker Selby voting no. Ms. Phillips. No. Ms. Phillips, no. Mr. Postles. Mr. Postles, yes. Mr. Ramon. Mr. Ramon, yes. Ms. Romer.
No.
Ms. Romer, no. Mr. Schwarzkopf. Mr. Schwarzkopf, no. Mr. Short. Mr. Short, yes. Mr. Shoup. Mr. Shoup, yes. Mr. Smith. Mr. Smith, yes. Mr. Spiegelman. Mr. Spiegelman, yes. Mr. Vanderwyn. Mr. Vanderwyn, yes. Mrs. Williams. Mrs. Williams, no. Mrs. Wilson-Anton. Mrs. Wilson-Anton, no. Mr. Yerrick. Mr. Yerrick, yes. Madam Speaker.
No.
Madam Speaker, no. Madam Speaker, the Roll call on the motion to table, 15 yes, 26 no.
Having failed to receive the motion to table, Senate Substitute 1 for Senate Bill 2 has been defeated. We are still on the amendment. Representative Giltner.
Madam Speaker, I just want to thank you. But I also think the way it's worded was, it was the defeat was to have it tabled, right, for the bill. It's not.
Voted.
So we go right back to the amendment.
Right.
Correct. Thank you, Madam Speaker.
So we're back on the amendment.
Yeah,
Representative Giltner.
Roll call, please.
Representative
Yeah,
Representative Giltner.
Roll call, please.
Representative Leader Brown.
Madam Speaker, you actually called on me prior to Representative Ramon standing up and giving his comments, so I would still like to speak on this unfriendly amendment. While I'm willing to have the discussion on an expedited permit process in certain circumstances, there would need to be a discussion around the feasibility and the execution with SBI and a careful examination of exactly what orders and what point in which the court process would be appropriate. Because those discussions haven't been discussed with any stakeholders yet, that is why I see it as unfriendly. But I would like to, at least, since we do have a stakeholder here in the building, ask if Marianne Kenville-Moore could come up in front of the chamber and give her perspective on this amendment. And this is the individual who represents the Delaware Coalition Against Domestic Violence.
Permission granted. Where's she? Please state your name and your organization.
I believe, yes, actually, I did. My apologies. Good afternoon. My name is Marianne Kenville-Moore, and I'm with the Coalition Against Domestic Violence. And I apologize. I was in the hall because I couldn't find a seat here to hear the conversation. So I missed if there was a question.
Oh, that's okay. That is okay. You are the stakeholder in reference to the Delaware Coalition Against Domestic Violence. So I would like to get your perspective on this amendment.
So the coalition just received and was reviewing this amendment today, as many other people have. And in my initial reading of it, it raised a number of concerns. The first being some of the comments that I heard Representative Griffith offered. Right now in the state of Delaware, people can apply for a protection order and receive one ex parte. It doesn't require that a hearing occur, and it doesn't clarify in this amendment whether or not a PFA would be an ex parte or a full protection order. We also have in Delaware a situation where we have a consent process where individuals can negotiate a protection order. And what we have found in the Family Court and the Domestic Violence Coordinating Council have been tracking these is we have many situations, statistically at least a third of our protection orders that are issued are considered cross petitions. So individuals are accusing each other. And so potentially we could have people who have protection orders and have protection orders against them. So again, this doesn't seem to be clear on that. But in terms of the study and statistics around self-defense, and as was noted, in that immediate and aftermath of a situation, what we know through study, and this is decades of study, is that when firearms are accessible, that victims of domestic violence, primarily women and children, are at 5 times greater risk of being murdered when a firearm is present. And so we are concerned that we would have a situation, especially with the exception of the training and the education, that we would have individuals who would be able to get a permit to purchase a firearm, not have the training, and then have the firearm used against them. The best practice is for us to work to develop safety plans with individuals, engaging law enforcement and others, not assuming that a person is going to have to create their own self-defense. My understanding is that this bill specifically is around handguns. And again, I'm not a firearm expert, But throughout my career, what I have heard is if an individual wants to have self-defense and they aren't skilled with firearms, that a shotgun would be a more appropriate firearm to possess. And so, having worked with many victims around these safety plans, we would work with law enforcement to develop those plans. So, and working with the Attorney General's office would be part of that as well. So for us, in this quick review of this particular bill, the elimination of the education, the lack of clarity around the PFA and the no contact orders, and then that escalation of violence potential when a firearm is present would cause us to feel like this would be an amendment that should not go forward, but perhaps explore other avenues to provide safety to people.
Representative Ramon.
Thank you, Madam Chair. This is a clean one, I'm sorry. May I speak with the witness? Thank you. So you know, we were together on the Family Law Commission for years, and I think you know me pretty well.
Yes.
And I think I would perceive that you knew the passion we had when we listened to some of these. Some couldn't even speak. Some were so terrified. My immediate level of relief of trying to prevent an unintended consequences that I thought would be received well in this particular environment, not that a woman would ever even use a handgun in this situation, but having one or being able to get to one, I felt a delay of going through this process may be very, it could be fatal. I mean, that's how, I mean, I'm truly, honestly scared to death of that. This isn't really about hurting a bill or fixing a bill. This was something I thought we missed, and I thought Valley, or our representative, had well defined that in our caucus. I do wish, like Sean said, we got to talk a little bit more, but that's a genuine concern. I hear what you're saying about someone not being prepared with a gun, but them not being able to defend themselves for that long. I know my wife would never hold a shotgun, but she might get a pistol, especially if, you know, she was scared, or especially if she's scared for her grandchildren or children. And I was trying to agree that that was something, an unintended consequence that maybe we could resolve. So if you could help maybe with the organizations that we both listen to so many times, give guidance. It looks like the obviously the amendment isn't going to be met as friendly, but I think we can still give guidance and try to prevent this very large unintended consequences with your help and some others. So, and I know Valerie knows an awful lot about it, so I'm going to let her render into her amendment, but thank you for your points.
Certainly.
Well, and I just...
Representative Giltner?
Yeah, I just want to clarify. The witness said that it eliminates the training, and that was your concern. It actually just delays the training.
You're correct. My apologies for misspeaking. It delays it, and it's the not having that training and having the possession of the firearm that creates. And in fact, I was reading studies about how, because frequently victims will talk with us about how it's important to develop self-defense, and we work with people around self-defense, but not having training and a firearm actually increases your risk of violence because you are not skilled with a firearm. And there's been good study to show, even my understanding from the firearm industry, to show that having effective education before use of firearms is really the most effective self-defense strategy that way.
And in all due respect, you're assuming that someone that's applying for a permit or needs to apply for a permit does not have any training. And there are some of us that grew up with guns. So I think the assumption that the training is not present just because they haven't gone to a nationally recognized course is untrue.
Thank you for correcting me.
Leader Minor Brown.
Thank you, Madam Speaker. May I have my witness excused, please?
Representative Bjork, do you have a question for the witness?
I do. Thank you, Madam Speaker. I appreciate your expertise and input on a very delicate situation, no doubt, when this comes about. When you mentioned the surveys and the studies, was that a nationwide study, a Mid-Atlantic study, or Delaware study? Where are those numbers pulled from?
Which specifically? Because I mentioned a few. So
you said there was a 5 times greater risk of death. Is that
yes.
National, international, domestic? I mean,
so that work actually is based on the work that Dr. Jacqueline Campbell has been engaged in since early 2001. She initially began her work in the University of Michigan, studying a series of homicides in the North region. But since then, she has expanded her study throughout the nation. In fact, there is a danger assessment tool that was developed and has been reevaluated to determine its validity. And so the statements that I made today regarding that gun safety and lethality are connected to her work.
So that was a national study.
I can't say it is a national study because she hasn't evaluated homicides and these issues in every state, but certainly a majority of states are using this lethality assessment protocol, and so it's one that has fairly broad exposure.
So another way to put it, it is not just an exclusive Delaware study. Is that
Correct.
safe
It
to
is
say?
not.
It's
It
not
is
an
not.
exclusive. Within that national study or studies you've done in Delaware, has there ever been research done to say, with the presence of a firearm, whether it be a handgun or a shotgun, how that has served as a deterrent in order to perhaps reduce domestic violence?
There have been efforts to determine that, but what, again, we have found, at least because of how crime and incidents are reported, is that we hear about the situations in which the firearm has been used to exaggerate the situation, not to prevent a situation.
So again, what you're saying, it's not been shown that a presence of a firearm is a deterrent. You don't have the numbers to back that up. You're not saying it is or isn't true. You're just saying that there's not been enough research done to show that with a firearm present, it's actually deterred domestic violence.
Correct. I just recently, while I was waiting, was doing a quick search, literature research, to see if there's any new studies to that point, and there still seems to be a gap in the research around what kind of deterrent a firearm presence might have.
Based on your so it could be a deterrent. You just can't. You haven't reached that conclusion yet, or the studies haven't shown. So it could actually be a deterrent, the presence of a firearm in regard to domestic violence, that it reduces the actual situation.
I can't say that it does, because there have been no studies, and efforts to study it have occurred, but it doesn't show.
So it's inconclusive. You just don't.
What it shows is that violence is escalated with guns, not that there is a deterrent factor.
In regard to the state of Delaware, how many reported cases of domestic violence are you aware of in a year?
There are generally 18 to 20,000 criminal cases and complaints that are filed with law enforcement on an annual basis. Our hotlines receive approximately 3,200 separate phone calls a year. It's hard to determine because, again, our studies, and these, again, go back to the Center for Disease Control, the National Institute of Justice. When they do nationwide prevalence studies, what they find is there's much more violence in families than ever come to the attention of authorities. So around 30 to 40% come to the attention of some professional.
In regard to a criminal charge, so that's awful, where if it's 20,000, there could be 50, 60,000 cases, situations of domestic violence. So a significant number are never reported.
Correct.
And like you said, you're not sure whether the firearm in that case or any case is actually determined or not, so that it could. So I'll just leave it at that there are a significant number of cases, what you're saying, that go not reported. And we're unsure if a firearm may actually reduce the cases that are reported or even unreported. So I just want to make that statement that there's a possibility, because your evidence doesn't show that's true or not true.
That's right. I mean, the possibility is there, but what we do actually have proof is that when firearms are present, it makes it more risky for victims. Study after study after study shows that firearms are a leading cause of homicide to women, unfortunately.
Leader Minor Brown.
Thank you, Madam Speaker. May our stakeholder be excused, please?
Any other questions? You are excused.
Thank you. Again, I see this as an unfriendly amendment. I would like to ask for a voice vote so we can get to the other amendments that the other party have.
I asked for a roll call earlier, please.
Representative Giltner, what was your, stand up and ask, please?
I would like a roll call, please.
Okay. Mr. Clerk, please read the roll on House Amendment 7 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback?
No.
Mr. Bomback, no. Ms. Bolden?
No.
Ms. Bolden, no. Mr. Bush?
No.
Mr. Bush, no. Mr. Carson? Mr. Carson, no. Mr. Chikwocha?
No.
Mr. Chikwocha, no. Mr. Collins? Mr. Collins, yes. Mr. Cook?
No.
Mr. Cook, no. Mrs. Dorsey Walker?
No.
Mrs. Dorsey Walker, no. Mr. Dukes? Yes. Mr. Dukes, yes. Mr. Gray? Yes. Mr. Gray, yes. Mrs. Griffith? Mrs. Griffith, no. Ms. Harris? Ms. Harris, absent. Mrs. Heffernan? Mrs. Heffernan, no. Mr. Hensley? Mr. Hensley, absent. Mr. Hilofsky? Yes. Mr. Hilofsky, yes. Mrs. Johnson? Yes. Mrs. Johnson, no. Mrs. Jones-Giltner?
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert? Mr. Lambert, no. Mr. Lynn? Mr. Lynn, no. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor-Brown?
No.
Mrs. Minor-Brown, no. Ms. Moore? No. Ms. Moore, no. Mr. Morris? Yes. Mr. Morris, yes. Mr. Morrison? No. Mr. Morrison, no. McNeil? McNeil, no. Mr. Osinski?
No.
Mr. Osinski, no. Ms. Parker-Selby? Ms. Parker-Selby, no. Ms. Phillips? Ms. Phillips, no. Mr. Postles? Yes. Mr. Postles, yes. Mr. Ramon? Mr. Ramon, yes. Ms. Romer?
No.
Ms. Romer, no. Mr. Schwarzkopf? Mr. Schwarzkopf, no. Mr. Short? Mr. Short, yes. Mr. Shoup? Mr. Shoup, yes. Mr. Smith? Mr. Smith, absent. Mr. Spiegelman? Yes. Mr. Spiegelman, yes. Mr. Vanderwyn? Yes. Mr. Vanderwyn, yes. Mrs. Williams? Mrs. Williams, no. Mrs. Wilson-Anton? No. Mrs. Wilson-Anton, no. Mr. Yerrick? Mr. Yerrick, yes. Madam Speaker?
No.
Madam Speaker, no.
Representative Hensley?
Mr. Hensley from absent to
Harris.
voting yes.
Absent to no.
Ms. Harris from absent to voting no. Madam Speaker, the roll call reveals 15 yes, 25 no, 1 absent.
Having failed to receive the constitutional majority on House Amendment 7 to Senate Substitute 1 for Senate Bill 2 has been defeated. Representative Collins, do you have an amendment you'd like to have read in?
Yes, yes, please. Please read in House Amendment number 8 to Senate Substitute number 1 for Senate Bill number 2.
Mr. Clerk, please read in House Amendment 8 to Senate Substitute 1 to Senate Bill 2.
Madam Speaker, House Amendment number 8 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Collins. Madam Speaker, this concludes the final reading of House Amendment number 8 to Senate Substitute number 1 for Senate Bill number 2.
Representative Collins, House Amendment 8 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. We're talking about a constitutional amendment here. Excuse me, not a constitutional, I'm sorry. We're talking about something that impacts a constitutional right in a very dramatic way. And one of the main fears of those who believe in both the federal Second Amendment and the Delaware section in the Constitution that speaks to our right to own a firearm is that the government may someday, after compiling a list of everyone who owns a gun, just come and take them in some way. So, obviously, this bill, Senate Bill 2, would certainly have the potential to allow the state of Delaware to create a list of firearm owners. So this amendment would simply do what federal law does. Section 103I of the Brady Act that forbids the creation of a firearms registry. Now, it does allow necessary access of records for law enforcement purposes, things like that. So on line 8, it says records may be accessed by a valid Attorney General subpoena, I'm skipping some words, or a valid court order. But the amendment would prohibit the creation of compiling of a list or database, and that is exactly what the Brady Act does on the federal level. However, of course, SBI can maintain a record of active and unexpired permits approved and issued under this section. Once those permits, though, have expired, they would be expunged and destroyed. And there is actually, to show that we would be serious about this, if someone decided to create a list anyway in violation of this amendment, they would be guilty of a felony. So that is the amendment. If there are no questions, I would ask for a roll call vote.
Representative Leader Minor Brown.
Thank you, Madam Speaker. I actually see this as an unfriendly amendment. There are existing FOIA exemptions that already apply to this process, but I am adding an explicit provision in my own amendment. The remainder of this amendment has not been discussed with any of the stakeholders, including SBI, so this is an unfriendly amendment.
So I have a roll call from Representative Collins. Chief Clerk, please read the roll on House Amendment 8 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback?
No.
Mr. Bomback, no. Ms. Bolden?
No.
Ms. Bolden, no. Mr. Bush?
No.
Mr. Bush, no. Mr. Carson? Mr. Carson, no. Mr. Chikwocha?
No.
Mr. Chikwocha, no. Mr. Collins?
Yes.
Mr. Collins, yes. Mr. Cook? Mr. Cook, absent. Mrs. Dorsey Walker?
No.
Mrs. Dorsey Walker, no. Mr. Dukes? Mr. Dukes, yes. Mr. Gray? Mr. Gray, yes. Mrs. Griffith? Mrs. Griffith, no. Ms. Harris?
No.
Ms. Harris, no. Mrs. Heffernan? Mrs. Heffernan, no. Mr. Hensley? Mr. Hensley, yes. Mr. Hilofsky? Mr. Hilofsky, yes. Mrs. Johnson? Mrs. Johnson, no. Mrs. Jones-Giltner?
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert? Mr. Lambert, no. Mr. Lynn? Mr. Lynn, no. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor Brown? No. Mrs. Minor Brown, no. Ms. Moore? Ms. Moore, no. Mr. Morris? Mr. Morris, yes. Excuse me. Mr. Morrison? Mr. Morrison, no. McNeil? McNeil, no. Mr. Osinski?
No.
Mr. Osinski, no. Mrs. Parker Selby? Ms. Parker Selby, no. Ms. Phillips? Ms. Phillips, no. Mr. Postles? Mr. Postles, yes. Mr. Ramon? Mr. Ramon, yes. Ms. Romer?
No.
Ms. Romer, no. Mr. Schwarzkopf? Mr. Schwarzkopf, no. Mr. Short? Mr. Short, yes. Mr. Shoup? Mr. Shoup, yes. Mr. Smith? Mr. Smith, absent. Mr. Spiegelman? Mr. Spiegelman, yes. Mr. Vanderwyn? Mr. Vanderwyn, yes. Mrs. Williams? Mrs. Williams, absent. Mrs. Wilson-Anton? Mrs. Wilson-Anton, absent. Mr. Yerrick? Mr. Yerrick, yes. Madam Speaker?
No.
Madam Speaker, no.
Representative Cook.
Mr. Cook from absent to voting no.
Representative Wilson-Anton.
Madam Speaker, the roll call reveals 15 yes, 23 no, 3 absent.
Having failed to receive the constitutional majority, House Amendment 8 to Senate Substitute 1 for Senate Bill 2 has been defeated. Representative Urick, do you have an amendment?
Yes, thank you, Madam Speaker. May I have House Amendment 9 to Senate Substitute number 1 to Senate Bill number 2 read in?
Chief Clerk, can you please read in House Amendment 9 to Senate Substitute 1 for Senate Bill 2?
Madam Speaker, House Amendment number 9 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Yerrick. Madam Speaker, this concludes the final reading of House Amendment number 9 to Senate Substitute number 1 for Senate Bill number 2.
Representative Yerrick, House Amendment 9 to Senate Substitute 1 for Senate Bill 2 is before us.
Thank you, Madam Speaker. The intent of this amendment is to try to proactively look at unintended consequences, to look at some of the most vulnerable individuals in the state. We just heard some terrible domestic violence statistics, which unfortunately still most of the time that are women are the victims, that we wanted to have an expedited process for individuals that, one, are in very dire situations, that to have a extended process of months where days, hours could be the difference in their life. Having an opportunity for individuals who don't have the means to financially do the training, let alone the permit, this is a way to have an expedited but still safe process to go through for those individuals where time is of an essence. Literally, when you see certain commercials for individuals suffering from a stroke or a heart attack, one of the lines is that when seconds matter, count on this. When seconds and days, hours matter, this is a way to expedite situations. Well, yes, there's still some components they have to pick up, but in regard to the mental health and suicide prevention, just having the permit process done, that's the intent of this amendment, to allow that expedited process still within the safety, the confines of the intent of the bill.
Leader Minor Brown.
Thank you, Madam Speaker. I see this as an unfriendly amendment. There has been no exploration of the cost, the security, or the feasibility of an online application process. And an online training would not allow for any live fire shooting exercises and practice in safety and handling. So I see this amendment as unfriendly.
Representative Urick.
Thank you, Madam Speaker. Let's have a roll call on this, please.
Mr. Chief Clerk, please read the roll on House Amendment 9 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback.
No.
Mr. Bomback, no. Ms. Bolden.
No.
Ms. Bolden, no. Mr. Bush. No. Mr. Bush, no. Mr. Carson. Mr. Carson, no. Mr. Chikwocha.
No.
Mr. Chikwocha, no. Mr. Collins.
Mr. Collins.
Mr. Collins, yes. Mr. Cook.
No.
Mr. Cook, no. Mrs. Dorsey Walker.
No.
Mrs. Dorsey Walker, no. Mr. Dukes. Yes. Mr. Dukes, yes. Mr. Gray. Yes. Mr. Gray, yes. Mrs. Griffith. Mrs. Gray.
Representative Griffith. Okay, go on.
Mrs. Griffith, absent. Ms. Harris.
No.
Ms. Harris, no. Mrs. Heffernan. Mrs. Heffernan, no. Mr. Hensley. Mr. Hensley, yes. Mr. Hilofsky. Mr. Hilofsky, yes. Mrs. Johnson. Mrs. Johnson, no. Mrs. Jones-Giltner.
Yes.
Mrs. Jones-Giltner, yes. Mr. Lambert. Mr. Lambert, no. Mr. Lynn. Mr. Lynn, no. Mr. Matthews. Mr. Matthews, yes. Mrs. Minor-Brown. Mrs. Minor-Brown, no. Ms. Moore. Ms. Moore, no. Mr. Morris. Mr. Morris, yes. Mr. Morrison. Mr. Morrison, yes. Excuse me.
No.
Mr. Morrison, yes. Hey,
No, he
sorry.
said no.
Hold on. Mr. Morrison voting no. My apologies. McSneil. McSneil, no. Mr. Osinski.
No.
Mr. Osinski, no. Ms. Parker-Selby. Ms. Parker-Selby, no. Ms. Phillips. Ms. Phillips, no. Mr. Postles. Mr. Postles, yes. Mr. Ramon. Mr. Ramon, yes. Ms. Romer.
No.
Ms. Romer, no. Mr. Schwarzkopf. Mr. Schwarzkopf, no. Mr. Short.
Yes.
Mr. Short, yes. Mr. Shute. Mr. Shute, absent. Mr. Smith. Mr. Smith, absent. Mr. Spiegelman. Mr. Spiegelman, yes. Mr. Vanderwyn. Mr. Vanderwyn, yes. Mrs. Williams. Mrs. Williams, absent. Mrs. Wilson-Anton. Mrs. Wilson-Anton, absent. Mr. Yerrick. Mr. Yerrick, yes. Madam Speaker.
No.
Madam Speaker, no.
Representative Griffith.
Mrs. Griffith from absent to voting no. Madam Speaker, the roll call reveals 14 yes, 23 no, 4 absent.
Having failed to receive the constitutional majority, House Amendment 9 to Senate Substitute 1 for Senate Bill 2 has been defeated. Leader Minor-Brown, House Amendment 10.
Thank you, Madam Speaker. I would like to have House Amendment 10 introduced and distributed and read in.
Mr. Clerk.
Thank you.
Need to pass it out.
Mine.
Mr. Clerk, please read in House Amendment 10 to Senate Substitute 1 for Senate Bill 2.
Madam Speaker, House Amendment number 10 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Minor-Brown. Madam Speaker, this includes the initial reading of House Amendment 10 to Senate Substitute number 1 to Senate Bill number 2.
Leader Minor-Brown.
Thank you, Madam Speaker. This amendment clarifies what information may be retained by SBI, and it explicitly exempts application and permit information from the Freedom of Information Act. Can I have a voice vote, please?
All those in favor for House Amendment 10 to Senate Substitute 1 for Senate Bill 2 signify by saying aye.
Aye.
Noes? Ayes have it. Having received a constitutional majority, House Amendment 10 to Senate Substitute 1 for Senate Bill 2 has been passed the House. Leader Minor-Brown, House Amendment 11.
Yes, thank you, Madam Speaker. I'd like to introduce House Amendment 11 and have it distributed and read in, please.
Chief Clerk, please read in House Amendment 11 to Senate Substitute 1 for Senate Bill. I didn't say 2.
Got one.
I didn't say 2 yet. 2.
Madam Speaker, House Amendment number 11 to Senate Substitute number 1 for Senate Bill number 2, sponsored by Representative Minor Brown. Madam Speaker, this concludes the initial reading of House Amendment number 11 to Senate Substitute number 1 for Senate Bill number 2.
Leader Minor Brown.
Thank you, Madam Speaker. So the amendment that we just passed, number 6, actually exempts a broad category of people from trainings. Not all of these persons were outlined are required to have a training to receive their title. This amendment allows them to be exempt if they are able to provide a record of their training that is equivalent to the requirements of the bill. Can I have a voice vote, please?
Representative Speigelman.
Thank you, Madam Speaker. Couple of thoughts. First, we haven't really had the chance to review this. We haven't ever really had the chance to take this to stakeholders. Now what we're being told is that the amendment that passed a few minutes ago, that the training requirements on that amendment, that the employers are going to be in a situation where they're going to be signing off on trainings. This puts them in an awkward position of having to potentially sign off on trainings that they're not really aware what they're signing off. It's going to require changes in trainings potentially. This hasn't been vetted in any of the groups that that are mentioned in that amendment. It's not vetted through police. It's not vetted through National Guard. It's not vetted through anybody who are going to have their members coming to them asking for this exemption, and we're just going to drop this on them at 6:15 on a Thursday and say, hey, by the way, your employers are going to be coming to you saying, I want you to sign off on these trainings, or I want these trainings to change based on the requirements in the permit process. This is a very substantial change, the amendment that we just passed, which was pre-filed. I would ask that this actually be ruled unconstitutional and be struck down because it's a substantial change being made at the very last minute and just dropped on us now.
Voice vote.
Madam Chair.
Representative Carson.
And
thank you, Madam Speaker. Open dialogue with the sponsor.
Granted.
I'd like to thank the sponsor for bringing this forth. The greatest trained people in firearms in the world are members of our United States military. We have a lot right here at Dover that guard our freedoms. They guard the president and the planes, and same thing up in Newcastle where you have Air Force and Army. Thank you for allowing this bill to come in to help protect all of us through veterans.
Representative Ramon.
Thank you, Madam Speaker. Can we please request our House Attorney, or even the Democrats' House Attorney, to explain, if this is out of order? Because this is fairly substantial, presented at the end of a long day on an amendment that was just passed. Could we have one of the House Attorneys come in and just render...
Karen Lance, are you available?
Or Ron Smith? So you heard my question, right? I'll restate real quickly. Just the fact that this amendment was pre-filed, already went in, went through the voting process, went through discussion, and then we have an amendment of an amendment that just passed, dropped on the floor, which what I would say is substantially changing the amendment that we earlier passed. Is that within the rules of the House?
Karen, could you please state
because
your name
it
for the record?
substantially changes.
Can you please state your name for the record?
So, Karen Lance, House Attorney. I'm sorry. So I actually was out of the room. Which House? We're on House Amendment 10? We're on 11. Okay.
11 was presented after Amendment, what, Jeff? 6? 6 was passed. So we had discussion, we had witnesses, we had a very interesting dialogue. And then after it passed, what I would suggest is a substantial change to that amendment has been presented. I'm not even saying I'm against it or for it. I'm saying we haven't even been able to discuss it with our attorneys or anyone else. The House rules suggest that you cannot have a amendment dropped on the floor that substantially changes anything without pre-notice. I would either ask that we table the bill and stop and talk about this, or this amendment is out of order.
Representative Ramon,
I was asking.
I know, but I'm just gonna step in here as the Speaker of the House. I'm going to rule this amendment in order, so I would like to move on with the bill. I don't think the lawyer has to make that statement. I, as the Speaker of the House, am making that ruling right now.
I understand. But I'm asking an attorney's opinion of whether it's out of order or not. I understand. You can do it,
I'm
but
going to tell you what my order is.
Yeah.
I'll let her answer that, but my ruling will stand.
I understand that.
Actually, I don't think that it is appropriate for a House attorney to say whether something is in order. That's the Speaker's to rule on, but I will say that I don't think it is so substantial as to be out of compliance with the House rules.
Thank you. And Madam Speaker, could I ask our attorney's opinion since she just walked in, just for clarity?
I will allow that, but I want to let you know that I still ruled it. So
I
thank
understand.
you, Karen.
Thank you, Karen.
Thank you.
Mr. Smith, I know. It's the first we saw it too. So it's the first we saw it too. So the question's fairly simple, though. It's not really about the amendment. It's about the submission of a amendment number 6 that passed the House. And subsequently, while we were going through other amendments, a new amendment was made, number 11, that substantially changes the amendment number 6 during the conversation. I thought we were told that that is out of order in the House. Now, the Speaker has rendered a decision that it's in order, but I'm asking you specifically, is that out of order in the rules?
Ron Smith, House Attorney. There is a specific rule drawing a distinction between a technical amendment, a typing error, spelling error, something of that nature that doesn't change the substantive outcome of what the item is trying to achieve. So a technical amendment can come up at any time with little warning, but a substantive amendment, the rule provides that is to be pre-filed unless the Speaker waives the pre-file.
Yes, and so I'm just showing you, this was the amendment to the bill, number 6. Would you perceive that would be substantive? It changes the classifications of people.
It's definitely not a technical amendment. It is a change that does have some impact.
And when we were in caucus for the last 2 or 3 days talking about this bill coming up, you were very much leaned on in our caucus, along with our senior members and others that were here, to give us guidance on trying to prevent unintended consequences, not a goal to kill a bill, but just try to make it a little better. And one of those guidance measures was passed. And this changes that. Does it change, with us not having time to digest this, does it change in your mind the unintended consequences that the previous bill resolved for what we were trying to do?
The previous amendment.
I'm so sorry, the previous amendment, yes.
It does have some impact on what that amendment achieved.
Okay.
That's why I would not say it's a technical amendment. It's certainly not a spelling correction or something like that. So I would classify it as substantive, and we have the one rule so that you wouldn't be surprised with changes at the last second that you weren't aware of. But the rule does allow the Speaker to allow that if they wish.
And I was just about to comment on that, but thank you. I will say, Madam Speaker, I am grateful for this whole amount of time that you've given us. I think you see we're sincerely trying to help certain aspects. I'm just concerned that we don't get to look this. I would obviously like it to be tabled and give us time, but I do respect your opinion, and I am thankful for you to give us the time to have the conversation. Thank you.
Representative Urick.
Thank you, Madam Speaker. I mean, you were going to make your ruling. I just want to go on the record and say we tried to be as genuine and upfront, and we're criticized for not allowing enough time to vet our amendments. We, too, could have filed them from the floor. We could have presented them from the floor. But we wanted to have respect to a process. Yes, we could have had these amendments filed a month, 2 months ago, 6 months ago, whenever the Senate passed the bill. However, to be respectful of the process, what we tried to do, yes, you have every opportunity, you have every right to rule, but you're going to rule on this. I find it a little disingenuous sometimes. We're going to talk a bit later about steps in the process where we feel have been avoided. That's going to be on the bill. I just want to go on the record that we tried our part to introduce these amendments where we too could have brought them to the floor. I don't know the outcome there. Perhaps they would have been ruled, hey, not respectful of the process. All we're asking for is consistency. And yes, as you said, you have every right to make that ruling, which you will. I just want to go on the record. We always ask for consistency in the process, and a lot of times we don't feel that's the fact. Thank you.
Ron, you're welcome to leave. If no questions for him. Okay.
No, not for Ron.
Okay, I have Representative Shue.
Madam Chair, I wanted to clarify what this amendment actually does. And,
Okay.
Who should I?
To Leader Minor.
Madam
Okay,
Speaker.
thank you. So I'm trying to go through this now because we just got it, and please correct me if I'm wrong. I as I look through this, I see that this amendment actually voids what we did in Amendment 6. In Amendment 6, we said that there's a list of occupations that get this sort of training, and this list of occupations is now exempted from having to go through this process under this bill. Now, with this new amendment, we're saying that they're only exempted if their training already meets the provisions inside the original bill. So we're not exempting all the individuals that we're exempting in Amendment 6. We're only exempting them now if their training lines up with the training that is in the original bill, kind of like the AG explained earlier to us. Is that correct?
So the bill is actually more inclusive than your amendment. Amendment 6 actually restricts certain people that technically would not have to have a training to receive their title. So that is why we brought this amendment forward, because your amendment exempts a broad category of people. Roll call.
I have Representative Postles. Did you have?
I'm not done with my.
Okay.
I'm not done with my
You have another question?
Madam Speaker,
Okay.
please. So, please, for clarification, this amendment says that individuals that have training for firearms under this amendment, that training has to meet up with the training that's in the original bill in order to not have to go through this process.
Repeat your question, I'm sorry.
Okay, so under this new amendment, if you have firearm training through your employment, that firearm training through your employment has to meet the training under this permit to purchase in order to be exempt.
Yes.
Okay, thank you.
Representative Postles, did you have a question? No. Oh. Okay, we're almost there. Representative Speigelman.
Thank you, Madam Speaker. With respect to my colleague, Representative Carson, I happen to agree with him entirely. It's one of the reasons why I brought the amendment, that some of the highest trained and most motivated people that we've seen in our country who get firearms training are our U.S. military, our servicemen and women. This amendment then says, oh, but that training that you get at the federal level means nothing if it doesn't meet our training guidelines here at the state level for a person to own a handgun outside of the military. It's a bit of a slap in the face, really.
Representative Schwarzkopf.
I heard the word voiding amendment number 6. That is not what they do. Basically, what it's saying is because 6 passed, we want to make sure that the people that are exempted have the training they're supposed to have. All they have to do is show proof that they already have the training. Now, I understand what you're saying, Representative Speigelman, about the children thing. They might not have that one component. So I want to make a broader statement here. I want to piggyback off what Representative Lynn said earlier. We've just gone through a list of 11 amendments, most of which neither side had a chance to really digest. Some of the amendments on our side, we had people that wanted to vote for some of your amendments because we liked some of the parts of your amendment, but we didn't like everything in the amendment. and with better communication, we can fix this. I will pledge to you, I will work with you to come up with another bill that will take some of your things into consideration, some of your amendments into consideration, and some of the amendments that we have over here, put them together, flesh them out, and come up with a better way of doing this exemption process. It makes no sense for a federal firearms license FFL permit holder who has gotten a federal license to have to now go and apply for a permit, a handgun permit, so that he can go buy guns that he's going to turn right around and sell. And this is just an oversight, and it's not been thought through on that side of it. So that's part of the process that I like that you guys brought up. I like some of the other things you guys brought up. I did not like some of the things that were in there. There's a couple in there that I don't agree with. There's one group that's in there that is definitely not law enforcement, but in that category of your amendments, it has them in there as law enforcement. So for those reasons, I couldn't vote for some of your amendments. But I like some of the things you said. And I like some of the things we have in our amendments. We tried to take care of things on the registry process that it's not actually a registry, but it looks like one. And amendment number 10 tries to limit that information that is allowed to be kept. So these are good things. It's a shame we had to do it on the floor here. We should have done something. We should have done a little bit better. You know, I should have been a little bit more involved in this thing. So bottom line is, I don't know what the vote count is. I have no idea. We still haven't voted on this amendment yet. But the bottom line is, if this bill passes, then we should get together and work to try to make it a better bill. Thank you.
Representative Spiegelman.
Thank you, Madam Speaker. And with respect to Representative Schwarzkopf, well, you know me, I'm willing to work with just about anybody on anything. But I think, if I may, to your point, I think that kind of bit shows why maybe this bill just isn't ready for prime time yet. That maybe there are some things that need to change. And importantly, if I can borrow Ramonism, there's no reason why this bill needs to be done right now, today. If there really are things that we can agree on to make this bill a little less objectionable to the people that we're proud to represent, maybe it's just not quite there yet. And I'll let you answer that, but Madam Speaker, I do have a line question once Representative Schwarzkopf.
Representative Schwarzkopf, do you want to reply to that?
I would just answer that the only reason we have these amendments, we're having this discussion now, is because the bill went on the agenda. So if the votes are there, I would imagine the vote's going to take place, and we can try to clean it up afterwards. But nobody was willing to sit down and have these discussions and put all these things in place until the bill hit the floor.
Representative Minor Brown.
Roll call, please.
It's being done today.
Okay, Representative Spiegelman.
Madam Speaker, are we sure this Amendment 11 is going the right line?
The what?
Senate Substitute Number 1 for Senate Bill Number 2 by inserting the following after line 134 and 135. I'm reading 134 and 135 as being the section about SBI retaining information and adopting regulations to administer and implement the section. Is that where this is supposed to go?
Karen Lance, could you come forward? Please state your name.
That's what happens with amendments. It doesn't make much sense.
Turn on the mic.
Okay. Karen Lance, House Attorney. It's inserting a new subsection that refers back to the subsection G that was created by House Amendment 6.
Representative Ramon, do you have a question for our attorney? Please.
Thank you, Madam Speaker. So my question is, obviously, now you got NPO. I probably should have been after line 135. But then when you go back and you look at the amendment that was written, the amendment that was passed, which falls between 64 and 65, and it has G and all the other, G with all the other qualifications under each of those, and you're putting that back here between 64 and 65 after line 5, a person who blah, 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 and before G, which is where this now falls. When you take this into consideration, I don't know that I think it's not correctly referencing right? Am I wrong? I'm not trying to say, I think it needs to be modified for us to really be able to do it, right?
So, Representative, I don't think that it needs to be modified. It's referencing an individual identified under subsection G, and subsection G is contained now in House Amendment number 6, and the reason that it's P is because the instructional language in House Amendment number 6 told the engrosser and or the code revisers to redesignate accordingly. So everything else that's in here is going to get bumped down a letter. So the existing N will become O, and the existing O would become P, except I have now inserted a new P because it seemed to make sense to insert this before usually the regulations authority is the last thing in the section.
Right, but I mean, yeah.
So it is very confusing.
I get it. It is confusing. I was just thinking
But I
it should
do
be on line
believe that it is in the
136.
right
That
place.
doesn't change the bill. What I was referring to, what you just said a second ago, though, is so in substitute number 1, right? You have 1 to 5, 6 to 9, 10, 11, 12, and you're referring that P says any individual in those categories, correct? Under the subsection of this section is exempt from the training requirements, correct?
I apologize. I did not follow what you just said.
So on the bill, on the amendment, right, you're saying that this new P, regardless of what line it should be on, all individuals identified under subsection G. So that's all of these, 1, 2, 3, 4, 5, 6, 7, this is the new amendment we just passed. So all the people under these, we're saying now that your amendment is saying the individuals under this section is exempt from the training requirement only if the firearm training undertaken in pursuit to their employment meets all the requirements of paragraph F4 of this section, right? Sort of what the discussion was a little bit ago about not getting all those educational, certain aspects of what's on that list of all the training. So what this is saying right here, instead of this bill saying the following persons are exempt from training requirements of this section, it's saying the following people are exempt from training requirements of this section if they not only have the training from their place, but it has to classify every single line to emulate it exactly, or they've got to go through the whole training. Right? That's what this amendment's doing.
I believe that your interpretation is correct, yes.
So in other words, it neuters this. Because there's very few people that are going to be in that situation. Very, very, very few.
So that, Representative, would be a factual question. I think SBI could figure out in its regulatory process which kinds of training that people on this list receive would qualify them without having to do any additional training.
I don't mean to be facetious. What I'm trying to say to you, so now we have this that has to go through another group to clarify this amendment that's not substantial in order and not changing this bill in a substantial way that we're even allowed to talk about this amendment. That's what you're telling me, right? Just checking. Yes or no is easy.
That is not exactly what I said.
I know it's what I said. I'm just teasing. All right. You get it. You understand where I'm going. Thank you.
You're welcome.
Representative Spiegelman.
Thank you, Madam Speaker. Question for the bill's sponsor, please. In the groups that we exempted during House Amendment 6, what if they don't have an employer? So the bill specifically mentions the firearm training undertaken pursuant to their employment. What if they don't have an employer? Some of those groups, we exempted them not necessarily because of their employment, but because of who they are, what training they get, because of hobbies or other things. So what happens to those who don't have an employer to go to?
Representative Spiegelman, if this person holds the certification of the title we are discussing and they have had this training within the last 5 years that qualifies, they are okay.
Well, with respect, it says this section is exempt from the training requirements only if the firearm training requirement undertaken pursuant to their employment meets all the requirements of the paragraph. Well, that seems like it would exempt an awful lot of the people that we enumerated in Amendment 6 because they don't have employment. In other words, they are there not necessarily because of their job, but because of other things. So if they don't have an employer that they can go to who's willing to sign off that this is part of their job, they then have to go back through the training as normal?
Well, when you get the training, you do receive certification that you've completed the training.
Yes, that's true. But this is saying only if that training is undertaken pursuant to their employment.
As their title, correct?
This says, and their employment meets all the requirements, and that training meets all of the requirements. So in other words, you could have somebody whose training meets all of the requirements, but still has to go through the permit to purchase because it's not part of their employment.
As long as they are trained within the last 5 years by a qualified training, they are fine. I think you know that.
But that's a different section. That's a different section. This is talking about the people who are exempt. And this is saying that those people are only exempt if the training is pursuant to the state training through their employment.
Representative Speigelman, would you like a more clarified response, a more technical response from the attorney?
Sure.
Okay, 1 second. Could we call Karen Lance, please?
Karen? Please state your name again.
Karen Lance, House Attorney. Representative Spiegelman, you are correct that the last couple categories on this list are not categories of employment. So I am not sure how SBI will interpret that.
Okay. So that would count for 10, 11, 12. 10, 11, 12. So these groups that we just said are exempt are not exempt unless it's their employment that is part of the exemption. That could also technically apply to Section 9. It could potentially apply to Section 8. So essentially this amendment guts an awful lot of what this House just passed for House Amendment 6.
Representative Spiegelman, would you like to add an amendment to the amendment?
No, Madam Majority Leader, and I appreciate the thought there. I really don't, actually. I'm kind of back to where I was before, and I respect you offering that. Where I was before is that maybe this bill just isn't ready for prime time.
It's an amendment, not a bill. We're still on the amendment.
Madam Speaker, the bill as amended, given that we're now going back and forth between competing amendments, is perhaps just not ready for prime time. That, look, maybe we do need another week. And if we did have another week, there's an awful lot of people on this side, and I'm sure some concerned members on that side, who would love to work on getting a lot of this worked out in a way that a lot of people would be much more comfortable with, would still strengthen the bill, still be able to do what you're trying to do, but not create these confusions, number one. And with respect, Madam Majority Leader, 1 week will make absolutely no difference to you. It will make absolutely no difference to the law. It will make absolutely no difference to the advocates who are here to testify both for and against the bill. 1 week makes no difference, but it could make a huge difference in getting the bill more right, has been my point. And so no, Madam Majority Leader, I don't want to do an amendment to an amendment. Really what I want to do is take a week.
Thank you, Mr. Spiegelman. This bill has been out since April 10th, 2019. It wasn't ready in 2019, 2020, 2021, 2022, 2023, 2024 now. You're still saying the same thing. You had since April 10th, 2019 to work on this bill with my caucus. If you would like to see some changes, I ask you to work with former Speaker Schwarzkopf. While you guys are working on the other clarifications to the amendments, work on that as well.
With respect, Madam Majority Leader.
Karen Lance, do you have any questions for the attorney?
No, Madam Speaker.
Okay, you have a seat.
With respect, Madam Majority Leader, this side of the room doesn't have control over the agenda, and there was no date certain for this bill until last night.
With all due respect, Representative Spiegelman, from the time that I've been here, the agenda's always been out the night before, and that has been the normal protocol for many years that I've been down here, so
Agreed. Yes, that's my
released.
point too, Madam Speaker. That's my point as well.
Madam Speaker, the minority leader said that they have had conversations in their caucus for the last 3 days. Can I please have a roll call?
Chief Clerk, please read the roll call on House Amendment 11 to Senate Substitute 1 for Senate Bill 2.
Mr. Bomback?
Yes.
Mr. Bomback, yes. Ms. Bolden?
Yes.
Ms. Bolden, yes. Mr. Bush?
Yes.
Mr. Bush, yes. Mr. Carson? Mr. Carson, yes. Mr. Chikwocha? Mr. Chikwocha, yes. Mr. Collins? Mr. Collins, no. Mr. Cook?
Yes.
Mr. Cook, yes. Mrs. Dorsey Walker?
Yes.
Mrs. Dorsey Walker, yes. Mr. Dukes? No. Mr. Dukes, no. Mr. Gray? No. Mr. Gray, no. Mrs. Griffith?
Yes.
Mrs. Griffith, yes. Ms. Harris? Yes. Ms. Harris, yes. Mrs. Heffernan? Mrs. Heffernan, yes. Mr. Hensley? Mr. Hensley, no. Mr. Holofsky? Mr. Holofsky, no. Mrs. Johnson? Mrs. Johnson, yes. Mrs. Jones-Giltner?
No.
Mrs. Jones-Giltner, no. Mr. Lambert? Mr. Lambert, yes. Mr. Lynn? Mr. Lynn, no. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor-Brown? Mrs. Minor-Brown, yes. Ms. Moore? Ms. Moore, yes. Mr. Morris? No. Mr. Morris, no. Mr. Morrison? Yes. Mr. Morrison, yes. McNeil? Yes. Mr. McNeil, yes. Mr. Osinski?
Yes.
Mr. Osinski, yes. Ms. Parker Selby? Yes. Ms. Parker Selby, yes. Ms. Phillips? Yes. Ms. Phillips, yes. Mr. Postles? Mr. Postles, no. Mr. Ramon? Mr. Ramon, no. Ms. Romer?
Yes.
Ms. Romer, yes. Mr. Schwarzkopf? Mr. Schwarzkopf? Mr. Schwarzkopf, yes. Mr. Short? Mr. Short, no. Mr. Shoup? Mr. Shoup, no. Mr. Smith? Mr. Smith, absent. Mr. Spiegelman?
No.
Mr. Spiegelman, no. Mr. Vanderwyn? No. Mr. Vanderwyn, no. Mrs. Williams? Mrs. Williams, yes. Mrs. Wilson-Anton? Mrs. Wilson-Anton, absent. Mr. Yerrick? Mr. Yerrick, no. Madam Speaker?
Yes. Representative Lynn?
Madam Speaker, yes.
Representative Matthews?
Mr. Lynn from no to yes. Mr. Matthews from yes to no. Madam Speaker, the roll call reveals 24 yes, 15 no, 2 absent.
Having received a constitutional majority, House Amendment 11 to substitute 1 to Senate Bill 2 is declared passed the House. We're going to take a short 10-minute recess because the people up here need we need a 10-minute break to, so we're going to take a 10-minute recess, so please just wait. And when we come back, we're going to go to the bill. No more minutes.